criminal law. It's a system of rules that defines what acts are considered harmful to society. It sets out punishments for those who break these rules. Essentially, it's how we, as a society, maintain order and protect ourselves from harm. The reach of criminal law is vast, touching upon almost every aspect of our lives. From theft to murder, from drug offences to cybercrime, criminal law provides the framework for addressing harmful actions. One of the first things to understand about criminal law is the concept of jurisdiction. Simply put, jurisdiction refers to the authority to make legal decisions and judgments. In the United States, we have a dual system of criminal justice, federal and state. This means that both the federal government and individual states have the power to create and enforce criminal laws. Federal jurisdiction typically applies to crimes that cross state lines or involve matters of national interest. Think drug trafficking, terrorism, or crimes committed on federal property. State jurisdiction, on the other hand, covers most everyday crimes that occur within a particular state's borders. This includes offenses like assault, theft, and DUI. Where do these criminal laws come from? There are three primary sources: common law, constitutional law, and administrative law. Each plays a crucial role in shaping the landscape of criminal justice. Common law is a system of law based on precedent. This means that it relies heavily on judicial decisions made in previous cases. Over centuries, judges have grappled with various criminal offenses, establishing a body of legal principles that continue to guide us today. These principles, often rooted in tradition and societal values, form the foundation of many criminal laws. Constitutional law safeguarding rights, defining wrongs. Constitutional law, as the name suggests, stems from the U.S. Constitution. This document, the bedrock of our legal system, defines the powers of the government and guarantees certain fundamental rights to all citizens. The Constitution explicitly prohibits certain acts such as treason and counterfeiting, while also setting limits on the government's power to punish. For example, the Eighth Amendment prohibits cruel and unusual punishment. Administrative law, regulations with teeth. Finally, we have administrative law. This branch of law deals with the rules and regulations created by government agencies. While not typically thought of as criminal law, administrative regulations can carry criminal penalties for violations. For example, violating environmental protection regulations or engaging in insider trading can result in criminal charges. The purpose of punishment, a spectrum of theories. Now, let's talk about punishment. Why do we punish those who commit crimes? What do we hope to achieve? There's no single answer, as different theories of punishment offer various perspectives. Incapacitation and deterrence, preventing future crimes. One common theory is incapacitation. This approach focuses on removing the offender from society to protect the public from further harm. Imprisonment is a classic example of incapacitation. Another related theory is deterrence. The idea here is to discourage future crime by making the consequences of breaking the law unpleasant. Deterrence can be specific, targeting the individual offender to prevent them from re-offending, or general, aiming to deter the public at large from engaging in similar crimes. Retribution, rehabilitation, and education, balancing punishment with reform. Retribution, often referred to as an eye for an eye, focuses on punishment as a form of justice. It argues that offenders deserve to be punished in proportion to the harm they have caused. On the other hand, rehabilitation emphasizes reforming the offender and reintegrating them into society as law-abiding citizens. This often involves programs like job training, counseling, and substance abuse treatment. Finally, we have education. This theory posits that punishment can serve as a learning experience both for the offender and for society as a whole. By understanding the consequences of criminal behavior, individuals can make more informed choices. Anatomy of a crime: actus reus and mens rea. To convict someone of a crime, prosecutors must prove certain essential elements. These elements typically include actus reus, mens rea, concurrence, and a harmful result and causation. Actus reus, Latin for guilty act, refers to the physical act of committing a crime. For example, in a theft case, the actus reus would be the taking of someone else's property without their consent. Mens rea, meaning guilty mind, refers to the mental state of the offender at the time of the crime. Conclusion: the evolution of criminal law. Criminal law is a complex and ever-evolving field. From its roots in common law to its modern interpretations, criminal law reflects our values as a society and our commitment to justice. As our understanding of criminal behavior deepens and new challenges emerge, the law must adapt to ensure fairness and protect the innocent while holding the guilty accountable.